The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This morning, we will have 4 cases submitted to the court. The 4th case, I will mention that now, is submitted without oral argument. Danielle Putman versus Sean Walther. That case is hereby submitted without oral argument. The first case set for this morning is State versus Jones. Mr. Miller, you may begin.
May it please the court, counsel. The Court of Appeals made 2 primary errors that led it to erroneously reverse the defendant's conviction. First, the Court of Appeals said that to prove actual possession, you have to find the drugs on the defendant. Second, the court treated circumstantial evidence as less probative than direct evidence in evaluating guilt. Starting with actual possession, this court in Vance and Thomas has said that you can prove actual possession by showing the defendant possessed drugs at a prior time. That is what the state did here. It was the state's theory that the defendant placed the drugs in front of his car shortly before he approached the officer. In other words, the state proved actual possession using circumstantial evidence, which this court has approved in Thomas. That sort of leads into the second error, which is that circumstantial evidence is less probative than direct evidence, that when relying on circumstantial evidence, the state has to disprove rational hypotheses of innocence. This court confirmed last term in State v. Ernst that that's not the case. The Court of Appeals was wrong to say that, and this court should correct that error so that those types of decisions don't keep creeping up into the jurisprudence and being cited in district courts. The evidence here was sufficient to convict the defendant. This court has to treat the reasonable inferences in favor of the verdict and view the evidence in favor of the verdict. Here, drugs were found in a black baggie 12 to 18 inches from the defendant's car. The defendant was the only person there at the time, which while might not conclusively prove possession, certainly supports it, and DeWitt supports that proposition. The bag was relatively clean. It was dry despite damp conditions. There was a Hy-Vee fuel saver card in the bag that belonged to a Facebook friend of the defendant. That eliminated people besides the defendant and that friend as possible suspects. It allowed the jury to do that. It also, there was no evidence that Titus, whose card it was at that location. No one testified that he was there.
Joe, regarding the identity of the driver of the vehicle that was in the ditch.
Set of keys found about 15 feet, I believe, from the bag of drugs that had another Hy-Vee fuel saver card that belonged to a Minnesotan named Rivera, I believe. I think it was assumed that that person was driving. I'm not exactly sure. There was some, I guess, doubt of whether it was that person or the Heidi Smith who called the defendant to ask him to come pull the car in the ditch out of the ditch. So I don't think it was conclusively shown who the driver of that car was. There was also a child in the car, and that was offered as why the people left instead of staying there. There was also the unbroken glass meth pipe, which showed that the evidence wasn't thrown from a passing car. There was the positive test of $200 bills in the defendant's wallet, as well as his driver's license, which allowed the jury to infer he had touched meth, and from there infer he touched the meth by the car. And finally, the defendant said that there was probably nothing good in the bag when asked by police. Now, he certainly denied possession, but by saying that there was probably nothing good, the jury could infer he knew that there was contraband in the bag because it was his contraband. All of that evidence allowed the jury to conclude that the defendant possessed those drugs and set them on the ground by his car just before the officer approached, and for that reason, it was sufficient to convict him of possessing the marijuana in the bag as well as the methamphetamine in the bag. And this court should reverse the Court of Appeals decision and affirm the defendant's conviction. Thank you.
May it please the court, counsel. I'm here today to represent Mr. Michael Jones, who was falsely convicted of possession of methamphetamine and marijuana. So we do ask that you affirm the decision of the Court of Appeals. I do acknowledge there were some problems with that decision, though, and we didn't have the benefit of the Ernst case at the time. So the stack of inferences that Judge Doyle talked about, I think that we can't rely on that solely, and that we have to not require the state to resolve any possible inferences in favor of guilt, but that we have to consider, I think, the totality of the circumstances and those inferences. That the law still must require that someone who is at the wrong place at the wrong time is still protected from, yes?
And though one that the jury can answer? I mean, aren't all of these issues things that a jury can sift through and figure out without us getting involved?
Though that the law has to protect against a situation where somebody could be in the wrong place at the wrong time, as I believe Mr. Jones was. And so some of those inferences, the proximity, that the evidence was there close to his car, but I think the Court of Appeals correctly analyzed that as if other people were jointly at the vehicle, because they had been there very recently. And if we have a situation typical, in my experience, where somebody is out on a gravel road somewhere far from civilization in rural Iowa, and the drugs are found right there by their car. But here we do have unusual circumstances, and every case should turn on its peculiar facts. The peculiar facts here that these other individuals had been there. Heidi Smith was the person who called Mr. Jones about coming to get the vehicle out.
What you're talking about as being that the Court of Appeals analyzed it with those other people in mind. Wasn't that the same evidence that was presented to the district court?
The evidence presented to the district court, yes. Yes.
So had that presented to them as a jury?
But some of the evidence, particularly if we look at the testimony of the deputies, both deputies said that it was possible that somebody else, particularly the driver, had left those items there. One deputy, Deputy Taylor, says it was more likely than not that it might have been somebody else because it had that fuel saver card from somebody else in that same bag. So it wasn't more likely than not that it was Mr. Jones. In fact, it was more likely it had been somebody else.
With the fundamental issue that I see here, and that is, when does a record become so speculative that you can't sustain a conviction? I mean, Justice McDermott has the point that ordinarily there's conflicts in evidence. We let jurors figure it out. Rarely are there airtight cases. They settle by plea bargain. So our task here is to figure out where do you draw the line between evidence that's sufficient to go to the jury and evidence that's too speculative to support a conviction.
I think that there may be cases where there is so much circumstantial evidence, and that giving that circumstantial evidence the weight that it does deserve, considering any direct evidence and any circumstantial evidence and the totality of the circumstances, but that in this particular case, given those identifiers of other people tied directly to that contraband. And also, this theory about that he had possessed it earlier at some other time. When the Deputy Long first approached, my client was in the ditch looking at the other vehicle. He had a flashlight with him. He's trying to check out the situation. Can he get the vehicle out? As the deputy approaches then, he comes around the vehicle and is friendly with the deputy. They go up and they look at the deer. And he's not making any furtive movements. He's not trying to hide or confront the deputy. In some of the other cases that have been referenced, there are circumstances where somebody's holding a door closed against law enforcement, or somebody takes off running to avoid law enforcement. He's doing none of those things. And frankly, if he was going to discard the contraband to avoid the deputy, putting it in plain sight in front of his own vehicle would not have been a logical place for that to happen. So I think we have to consider the logical inferences of all the evidence and whether that substantially supports that verdict.
Is there any testimony or evidence regarding the electronics that were found at the scene, the cell phones and the Bluetooth device?
Motion to suppress, that was successful, so some of that evidence was excluded and not given to the jury.
What did that show?
What's called a Kensington puck that was in the contraband, and that did show that a link then with my client's cell phone. But that was an inventory search that discovered those things, and so that was excluded after Ingram.
They didn't testify about that when they were, okay, thank you.
Not any information that was presented to the jury, and so not fair to consider that as substantial evidence in supporting the verdict.
Let me follow up on the actual possession argument. You heard counsel suggest that you don't need to have contemporaneous actual possession. That strikes me as correct. And so the Court of Appeals may have overstated that principle of law. Do you agree with that, or am I missing something?
There could be direct evidence of actual possession at an earlier time. An eyewitness, for example, could have seen the person with the contraband, and we don't have any of that kind of evidence here, no direct evidence. And just kind of Judge Doyle lays out 5 different things that he thought did suggest some guilt. The look back, maybe he's looking back at the vehicle, maybe he's looking back at the contraband. The condition of the bag, that it had been placed there recently, but that's fully consistent with it would be having been left by those other individuals who had recently been at the scene. The fuel saver card of his Facebook friend anyway, that maybe that eliminates someone other than either Mr. Titus or Mr. Jones. Just the comment about probably nothing good, but what the officer said, Deputy Long says, he could see a meth pipe as the bag wasn't completely singed. We don't know if Mr. Jones may have seen that also, and maybe just the circumstances, deputies approaching him with this bag, that it probably wasn't going to be a good situation. And then the residue on his money and his license. That was the extent of it. There wasn't more evidence to support this verdict, and we believe that it was not substantially supported by that evidence.
In Ernst, we distinguished Truesdell on the basis that we said Truesdell involved just a single piece of evidence. Is this a case where the state really was relying on a single piece of evidence, just his proximity, or was there additional?
Judge Doyle said, too, that was the strongest piece of evidence, was proximity. And we know...
Was there other evidence that would have also tied him to it besides his proximity?
Besides the proximity, that it had been placed there recently, but again, that was wholly consistent with other people having done that. That it was some friend of his that was linked to the bag, but he was going there to help a friend of a friend, and so that might have been a friend doesn't seem to me to be strong evidence of guilt beyond a reasonable doubt here against Mr. Jones.
A question, and I want you to correct me if my factual premises are wrong, but as I understand it, this bag was 12 inches by 18 inches, maybe, something like that, and was located in front of the right passenger bumper. Is there any evidence that your client was in that area?
He comes up out of the ditch, that he came around the front of his vehicle. So he had been in that area, but nothing about the video suggested that he's, stopping to place something. And also, would have had that opportunity to place something in the ditch, frankly, if that was his intent, not in plain sight in front of his own vehicle.
The record shows he would have had to have taken this bag into the ditch with him and then dropped it on the way up.
Right.
Retrieved it from the vehicle, right?
He didn't have a chance to retrieve it from the vehicle, I don't believe, because he comes out of the ditch and then they go see the deer. They don't return to the vehicle, and he doesn't go back in his vehicle until he's asked about his driver's license and information.
On the officer's video, he could have been messing around in that vehicle that was in the ditch, correct?
That it might have been in that vehicle, and he might have...
Could have concluded that he's called in, he's a methamphetamine dealer. He knows there's that stuff in the car, he wants to get it out of there. He pulls it out, the cop shows up, and he places it under the front passenger bumper, right?
that basically illustrates kind of the lack of proof that we have in this case, because that maybe that is a likely scenario, that there are many likely scenarios, I think, presented by the evidence, but the evidence that would point towards guilt was not substantial enough to support this verdict. And that's why we would ask that you affirm the decision of the Court of Appeals. Unless there are any other questions? Thank you.
So to briefly clarify, the bag is a sunglass bag. It's not an 18 by 12 inch bag. It was found 18 to 12 inches in front of the car, so he could have retrieved it from the car in the ditch. He could have taken it out of his pocket. The video shows him walking right in front of his car where the drugs were found by the officers. And I think this argument illustrates lots of things the jury could have found, but
Clock. Sorry.
I'm good to go, or?
I guess not. Can we get the clock going again? I have a feeling you're not going to violate the time anyway, but help is on the way. There's a song that called that. You know what? I'm paying attention on my clock here. Go ahead.
So the jury could have found those things, but it didn't. On review of a conviction, we need to take the inferences in the state's favor, credit them, and decide if that is sufficient to prove conviction. For the reasons that I explained in my brief, and previously it was, and so we would ask that this court reverse the Court of Appeals and affirm the sentence.
Kind of the same question I asked your opposing counsel. What was there besides just his proximity that the jury could have relied on to make the inference that it was him as opposed to someone else related to the car?
Him walking right by the spot where the drugs are found.
Can you see whether or not he makes any kind of movement to drop anything, or as he's walking by, can you tell?
He does look back on the video towards the spot where the drugs are found. The drugs were worth $800 and packaged for sale. The jury could certainly find that a person wouldn't abandon that unless faced with police intervention. There was the...
That would be this... So your point there is that it's him as opposed to someone else from the car wouldn't have abandoned it.
That's correct. The dry nature of the bag, that nothing was broken. All these facts come from the bag, but they're not just he was next to the bag. There's circumstances about the bag and the nature of its contents. And then, of course, the fact that there was methamphetamine on 2 bills in his wallet, as well as his driver's license, is a further fact that isn't just the location of the bag. And so for those reasons, this case isn't one like Truesdale. The evidence was sufficient. We would ask that you affirm the conviction and reverse the Court of Appeals. Thank you.
The case of State versus Jones is hereby submitted. The second case is in re Marriage of Miller. And by the way, after the second case, we'll take a brief recess and then we'll reconvene for the third case.